In 1957, the English courts were faced with a case that would shape the very definition of recklessness in criminal law. The case involved James Cunningham, who lived with his future mother-in-law at a house in London. One evening, he removed a gas meter from the wall of the house in order to steal the money inside. Now, this just so happened to also be the gas meter for the neighboring property, and so by removing it, he caused gas to escape into the adjoining property. The occupier of that property inhaled the gas and became seriously ill. So prosecutors charged Cunningham under Section 23 of the Offenses Against the Person Act 1861, which made it a crime to unlawfully and maliciously administer a noxious substance. Now, the relevant part for our purposes is that it's a crime to administer the substance to any person in a way that is malicious. And that's the problem. What does maliciously mean? Did Cunningham have to intend to cause the harm, or was it enough that he acted recklessly? In other words, did he foresee the risk of harm, but go ahead and do it anyway? Well, this wasn't clear, and so it went to the Court of Appeal. Let's analyze the judgment. The first thing to note is that everyone agreed that Cunningham acted with the necessary mens rea for murder. That is, there was no dispute that he removed the gas meter in order to steal the money inside, that he knew that this could cause gas to escape, and that he was therefore at least negligent in his actions. However, the trial judge directed the jury to find Cunningham guilty of the offense under Section 23 if they felt that he had acted with wicked or evil intent, as was understood at the time. The jury rejected this interpretation of malice and found Cunningham not guilty. The prosecution appealed this decision and asked the Court of Appeal to find Cunningham guilty of the offense on the basis of a different definition of malice. So, what did the court say? Well, in reaching their judgment, the court considered two previous cases. In the first, a person had been convicted of murder for throwing a missile out of a train window, where a woman walking along the platform below was hit in the eye and killed. The court said that while it may have been negligent, it was not malicious for the person to throw the missile without looking to see whether anyone was on the platform. The court said that malicious in this context meant that the person must have intended to kill or to hurt someone. The second case involved a person who threw stones at a group of people, intending to hit one person in particular. The court again said that this was not malicious because there was no intent to hit anyone in particular. The person had merely thrown the stones in an angry manner. In light of these authorities, the court concluded that the word maliciously in Section 23 of the Offenses Against the Person Act 1861 should also require an intention to harm. However, this left a significant gap in the law. If Cunningham had intended to remove the gas meter, but not to cause any harm, then he could not be convicted of the offense because there was no evidence of any ill will towards his neighbor. But if, on the other hand, it was enough for the prosecution to show that he had acted negligently, then arguably anyone could be convicted of this offense just by proving that a reasonable person in the defendant's position would have foreseen the risk of harm. This could not have been what the lawmakers intended. Ultimately, the court settled on a definition of recklessness that has become widely accepted in English law. Lord Parker C.J. stated that maliciously in Section 23 does not simply mean acting with ill will. Instead, it requires either 1. An intention to cause the specific type of harm that in fact occurred, or 2. Recklessness, which is where the defendant foresaw the risk of harm but went ahead and took the risk anyway. In other words, the court held that the definition of malice should not turn on what a reasonable person would have foreseen in the circumstances, but instead on what the defendant actually foresaw and decided to go ahead anyway. This became known as the Cunningham recklessness test. On this basis, the court allowed the appeal and ordered a new trial. The Court of Appeal quashed Cunningham's conviction and ordered a new trial. But the case left behind a lasting principle. Recklessness in criminal law means conscious foresight of risk and choosing to take that risk anyway. If you enjoyed this episode, please subscribe to the channel for more. Leave a comment with your suggestions for future episodes and share this with your classmates. Check out our International Criminal Law and Criminal Justice playlist for more bite-sized criminal law delivered straight to you. Thank you for watching.